Good morning. My name is Advocate Mohammed Abdulrauf. Thank you for joining our live webinar on Facebook Live. The topic, child custody and child maintenance, whereby you can pose questions and I will try my best to answer them for you. Anything relating to child custody and child maintenance. When we speak about child custody, we're basically talking about the caring of a child, day-to-day decisions, where a child will live during the week, when he or she attends school, weekends contact by either parent, guardianship issues, for example, what school a child should go to, who should consent for that, relocation, a child moving with one parent to a different province, the application for a minor child's passport. Both parents have to consent. The same applies to relocation or a child visiting a different country. That is where both guardians have to consent and so on. That deals with child custody. Generally, there will not be any issues regarding child custody if the parents are living in the same home and they can come to an agreement regarding all aspects of the minor child's life. But the problems usually arise when parties separate. There is no longer one home. There are now two homes, two lives basically. The mother has her own life, the father has his own life, and the child will have to now fit into those parents' lives. He or she will have to live maybe 1 week with one parent and another week with a different parent, alternatively with the one parent during the week and every second weekend with the other parent. The reason why we propose every second weekend contact, it's not a hard and fast rule. Many parents go against it and they have their own workable parenting structure. But the reason why we propose every second weekend as opposed to every weekend is that the primary caregiver, he or she would require a weekend or every second weekend to bond with the child, to have fun with the child, to go out to the malls, to go to the beaches and so on. That would not happen during the week, because during the week the primary caregiver would be involved in taking the child to school, doing the homework, extramural activities, having the child sleep early, etc. And if we afford put it this way, the secondary primary caregiver or the parent that exercises contact to have contact every weekend, that basically means that the primary caregiver will not have any opportunity on having fun time, bonding time with a minor child. I see a question came in. If you have any questions, feel free to pose it on the Advocate Mohammed Abdulrauf Facebook page, and I shall try my best to deal with it. Let's deal with the first question. It says the following. Can you contest the Family Advocate report, and how do you go about doing this? Thank you for that question. Let me try to unpack that. Who is the Family Advocate, for those of you who do not know? The Office of the Family Advocate is a government position in terms of legislation. I am an advocate myself, but I'm not a family advocate appointed by the minister or in terms of legislation. The Office of the Family Advocate, in my view, would be the eyes and the ears of the court. They would appoint social workers to consult with the parents, to consult with the kids, and they provide recommendations to the court. So basically, you have a scenario whereby you will have your private social worker, your private psychologist, where the parents can pay for, and they will provide some type of report They will investigate the matter, and their input is very relevant and very useful. And on the other hand, we have the Office of the Family Advocate, who is state appointed. They can do the same, maybe not on all levels, but at the end of the day, there is a family advocate, a lawyer, somebody who is admitted as an advocate, and he will ultimately oversee the process should a social worker be appointed to do an investigation and so on. But if the matter is extremely intricate and the social worker is not equipped to deal with a specific scenario, let's say we're dealing with some type of serious psychiatric issues, serious parental alienation, things that are very complicated, drug abuse, alcohol abuse, neglect and so on, and the social worker might not be the best person to deal with this. Even if the Office of the Family Advocate cannot source an expert who is capable of dealing with that, then an outside person might be appointed, a childcare expert, clinical psychologist, etc. The parties may have to pay for it. It might be government appointed, I do not know. But then the family advocate himself or herself will have to look at their reports, their recommendations, and they will give their view on the issue, and that specific view will obviously also be presented to the court. So long and short, the Office of the Family Advocate is, I would say, a psychological department that deals with the child's best interest, but not a private department. It's a public department. And they are basically the ears and the mouths of the court, which I've mentioned early on. The ears and eyes of the court. When parties get divorced and they enter into a settlement agreement, into a consent paper, that specific consent paper and settlement agreement is usually sent to the Office of the Family Advocate to have a look at, to study it, and so on, and they will basically endorse it if they are happy with what's stated in that settlement agreement. The judge will look at it, and if there are any queries raised by the Office of the Family Advocate, the judge will obviously have to deal with it before pronouncing a decree of divorce. The Office of the Family Advocate does not deal with the propriety aspects of your relationship, property aspects. They only deal with issues concerning the child. Okay, that was the introduction on the Office of the Family Advocate. The question was, I'll repeat it one more time, can you contest the Family Advocate report, and how do you go about doing this? You are allowed to contest any report. Any professional report, you're welcome to do so. But after you have contested it, and I will deal now how you possibly could contest it, after you have contested it, the court will obviously have to make a decision. Am I, placing the same amount of weight on this report had it not been contested, or am I disregarding the contesting of it? So you should have very good reasons to why you want to contest it. One reason could be based upon the report itself, the contents of the report. If the family advocate piggybacks on someone else's recommendations, or the family advocate did not do an in-depth investigation, which he should have done, the family advocate thumbsucked, the family advocate guessed, the family advocate relied on facts which were not factually true, allegations which were not factually true, and etc. So there could be 1,000 reasons why I would contest a family advocacy report, but each case is different. I dealt with matters in the past whereby the family advocate basically relied upon another expert in coming to his or her conclusion. The family advocate did not apply his or her own independent mind to the matter. Another example would have been whereby the family advocate's office, I'm not mentioning any cases or any body specifically here, but there's only allegations which my clients brought up, where the family advocate's office made a few factual errors in the documentation, and my client contested it. He says, we did not say that, and because of that specific allegation which the family advocate said my client has made in his or her office, the family advocate made a certain type of a recommendation. And what sometimes happens is that the parties go for mediation session, and the family advocate presumes the matter is mediated because the parties presented themselves in that specific fashion. But later on it comes about that the parties did not intend to settle on what the family advocate presumed they wanted to settle upon. It's hard for me to comment on what happens in the family advocate's office because those mediation sessions and those specific investigations and assessments, legal representatives do not necessarily partake in it, and they shouldn't partake in it unless it's very necessary for them to sit in it, because the family advocate will have to take out his tools and deal with the specific situation at hand. So it is possible to contest it. The end of the day is the court will have to determine whether or not your basis for contesting the family advocate's recommendation is sound, is logical, and is a basis for it. A general way of it being contested would be if there is a conflicting view on the case, where two experts recommend two different types of relief or, a way of solving the problems between the parties. So the family advocate might recommend that the father has primary care, and another expert, also jointly appointed by the parties, recommends that the mother has primary care. And the way in which they have come to that conclusion, both of them sounds logically sensible and workable, but there's a conflict. Therefore, you would obviously have to now challenge it. If you are the father and one report is in favor of the other party, then you would want to challenge it and you say, no, I would like the court to follow my expert or this other expert's recommendation, and these are the reasons why. At the end of the day, evidence is presented to the court either in affidavit format or orally, depending upon what court you're appearing in, and via experts, social workers, family advocates, etc. I've dealt with a matter recently whereby the court had before it previous experts who recommended X, and a year later the matter was back before the court and we had different experts on board and they recommended Y. Obviously the court had to follow the more recent experts reports, but it's possible that a court would be in a difficult position whereby the court will have to make a decision. What am I doing? Who do I follow? I obviously have to listen to the experts. I will ultimately still make my own decision because the court is not bound by the decisions of any expert. But if experts are there, they have obviously consulted with the parties. That's invaluable information. They consulted with the child. Otherwise, the court will only have before it three sets of documentation, affidavits, and the arguments of the lawyers, and the court will not have had any insight or any independent insight as to what the true facts of the matter is. So that's it. That's regarding contesting a family advocate's report. You can contest it with good reasons. You need to convince the court for the court to disregard it. And the same goes to any report from any expert, social worker, psychologist, clinical psychologist, anybody. You can contest it. I have an additional question. Thank you very much for posing it. And sorry, before I go on, the person who posed the first question, you are welcome to ask any additional questions on what I have answered. The next question goes as follows. What would the family advocate view as a reasons not to give 50-50 care and contact for kids 6 and 8? So 50-50 contact is not something which is strange. It happens on a regular basis, and usually it would happen firstly where the parties come to that agreement. The parties have separated and they said, it makes logical sense. Let the child stay with you for 1 week and with me for 1 week, or 5 days with me and 5 days with you. Whatever makes workable sense for the parties, and they come to that type of conclusion. Then there's the other scenario whereby one party believes that shared care or 50-50 care would be in the child's best interest, and the other party believes no, it will not. Usually the party who has primary care believes it will not be in the child's best interest. Then the matter will obviously have to go to court. And how will I unpack a matter like that? I will obviously have to look at the matter holistically and determine, does it make logical sense for 50-50 care? For argument's sake, let us say the father lives 50 kilometers from the mother's home, where the child primarily resides. The child's school is 5 minutes away from the mother's home. And if they share 50-50 care, it would mean that the father would have to collect the child every afternoon, driving 50 kilometers from his workplace to the child's school, collect the child, let the child drive 50 kilometers back home, and in the next morning drive 50 kilometers back to the child's school. Let's say that 50 kilometers takes about an hour. I'm stuck in here. So in 1 week, the child will have to wake up at 6 o'clock to get to school on time. And on the other week, the child can wake up at 7 o'clock to be on school on time. So that wouldn't make sense. 50-50 would not make sense in my view if those are the facts. Alternatively, the father works or the mother works. They are at work all the time and they would not have time to attend to the child's homework, extramural activities, etc. Therefore, 50-50 would not make sense, because while the child is at the primary caregiver's home, for argument's sake, the father tends to the homework, extramural, music, take the child to piano if the child is a music student, whatever the case may be. And the father does that. And the child excels very well. But then the next week comes, the child's homework isn't done. The child's extramural isn't attended to because the other parent does not have time to do that. It doesn't make logical sense for that. So the 50-50 regime is a very useful regime, and I think it's wonderful if the parties can agree to it. And they can only agree to it if the circumstances surrounding it make sense, even if the parties agree to it. And the child is being detrimentally affected by that. We will go back to the 50-kilometer example, where the father in our example lives 50 kilometers away from a child's school. The child will be prejudiced thereby. And in my view, it will be selfish for the parents to do a 50-50 regime, unless it's necessary. Don't get me wrong. I mean, some people, they require the 50-50 in order to work, in order to do things that's very important in their lives. And unfortunately, the child will just have to, tag along and deal with that. That's something else. But for one parent to be adamant, I want 50-50, I want to have the child with me every half the month or half the year. But if it means that the child should now be prejudiced by being late for school, the homework not being done, having third parties care for the child because the father is at work, and so on, then I think the parties need to relook the matter. And I would not advise 50-50. But if the parties have come to that conclusion, I'm not here to step on anybody's toes. If that is their family dynamics and they think that's best for their kids, then wonderful. I believe that if parents come to an agreement and it's workable for them, no agreement will be perfect. No one is perfect. No scenario is perfect. If the child becomes a B student as opposed to A student, that is where the child is. That's the child's station in life, and those are the circumstances that the parties are living in. However, if there's a dispute and one parent believes that 50-50 will not work, and other parent believes that 50-50 will work, and then the matter goes to court, it comes before my office, to my office for some advice, or to take the matter to court, then I will unpack the matter as I have done now. I will look at the logic of the case. Is it reasonable? Is it rational? Is it in the child's best interest? Then I will proceed on that basis. Then we take a child-centered approach. Remember, the courts, social welfare, and those organizations, they do not get on board or involved if the child is not being neglected, and the parties came to an agreement regarding how the child should be cared for. They won't get involved. They only get involved if there is neglect, abuse, and so on. So parents, please, if you are thinking about 50-50, it's a wonderful idea. I love the idea because it does not necessarily mean that the child will not see the other parent at all during the during the period when he or she is not with the other parent. There is WhatsApp video, there's Zoom, there's FaceTime, there's WhatsApp calls, there's phone calls, etc. So communication can still take place. The child knows that in a week's time I will see my other parent, but during the week I will be busy, communicating with him in the evenings. So the child might become accustomed to that, and it's workable. As long as the parents find it workable, I am happy with that. So that's our second question. I hope I answered it. If I have not answered correctly or did not deal with everything you mentioned, please feel free to comment further. While I'm waiting for any additional questions to appear, I'll deal with the issue concerning child maintenance. Now, child maintenance is an important aspect in separated parents' lives, because if child maintenance is not paid, other problems arises. Child maintenance gets paid for educational expenditure, the child's education, and with education comes a lot of other aspects, extramural, sports, etc. Child maintenance gets paid, it will get used for food. Without food, we'll all be dead. No one can live without food. And shelter. Without shelter, without a place to stay, without accommodation, either rental or whatever the case may be, being an apartment, a home, whatever the case may be. Without that, you will be living in the streets. That is where your money goes to. So therefore, I'm a big fighter, a very vicious fighter when it comes to child maintenance and parties not willing to adequately support their minor children. Obviously, if someone wants to pay child maintenance, he is paying child maintenance or she is paying child maintenance, and there's a dispute regarding the exact amount, no, that is fine. I mean, people are welcome to dispute. The mother wants the father to pay for the pony rides, and the father said it's not necessary, he can't afford it. Maybe he can, maybe he can't afford it. We can debate that at the hearings, and he's welcome to say what he wishes to say. But for parents to outrightly say, I do not want to pay child maintenance because the mother must pay the child maintenance, child was born out of wedlock, she tricked me, etc., that's nonsense. You have a legal obligation to feed your child, to educate your child, and if you do not do that, the law will come. So with child maintenance, there is a process of applications for child maintenance at the maintenance courts. You approach your local maintenance court if you're the primary caregiver, where you reside, or where you work. What I usually do is I advise people, go to your local police station and ask them where the maintenance court is. Quickest way to find out where to go to. Sometimes you might live in one area, but your maintenance court might be somewhere else. You know what I mean? So you might live closer to one court, but because you live on the border, you might have to go to a different maintenance court a bit further away. So just find out exactly where or which maintenance court you have to approach. So there's an application, there's a variation. Let's say there is a maintenance court in place, maintenance order in place, my apologies, and you feel that the maintenance amount is unfair because you are now earning less money, or the other party is earning much more money, or the minor child cost much less than the minor child used to cost. The minor child received a bursary. The child is going to a different school. When the child was in primary school, the school fees was very expensive because it was only private schools that were available, but now the child is in a public school and the child is happy there. So things have changed. You can approach a court for a variation of the maintenance order. Please remember that. The other aspect of child maintenance could be where one party does not pay child maintenance in terms of the maintenance order, and then there is then you may approach the maintenance court and lay a criminal complaint against the other party. So that's something which you can do. Alternatively, the maintenance court can issue a garnish order, whereby the employer of the person who is not paying in terms of the maintenance order has to pay the maintenance on the employee's behalf. So that's it. Ladies and gentlemen, I hope I've been of some use for you this morning. I see no further questions. Thank you for those who have posted those questions, and thank you to all of you who have partook in this webinar. I hope you have a lovely day, and I shall see you online soon. Thank you very much.